I was asked to present a theme of my interest, and friends, being a student of constitutional law, of course, my first preference would always be going to the Constitution, because how much ever you study, you keep on studying as far as Constitution is concerned, and that is basically which prompted me to take this particular theme, that is certain basic understandings on originalism versus living constitutionalism. Now friends, the first question which prompts our mind is, why do we need to have a discussion of this nature? I would like to quote the words of the architect of the Indian Constitution, the chairman of the drafting committee of the Indian Constitution, Dr. B.R. Ambedkar. Constitution is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of the age. So, it is always subjected to the content of Constitution, or the words which is imprinted in the Constitution changes with the onslaught of time. That's what I would understand or infer from the wordings of the quote which is being given here. So that really prompts us to discuss this particular theme. Now my focus of the discussion here today would be as to what is Constitution, the difference between Constitution and constitutionalism, what is originalism and its difference with living constitutionalism. And since living constitutionalism and originalism were the ideologies which came out from the American constitutional discourses, we will be looking into its growth and its discussions in the American constitutional scheme, and finally its reflections or its manifestation in the Indian Constitution. Now basically we need to understand that what is a constitution in order for us to understand what is constitutionalism. Friends, I will just give a basic level of understanding as to what is constitution. As all of you would be aware of, constitution is the basic or the fundamental legal framework which lays down the structure, powers and functions of the state, and it also includes the rights as well as duties of its citizens. So it, as all of you know, it lays down the different organs of the government. There's also our rights against the government. So our rights against the government acts as a limitation on the governmental power. And why do we need a constitution? You find that this particular reason why every modern democracy has a constitution would be associated with the answer that it might be with the onslaught of time of a particular state, when the state is being formed, or a major change which occurs at the national level, which would have prompted a group of people to think that we need a constitution. Let's go make a quick glimpse of the various experiences in the Western world, in different countries, as to how they adopted constitution. Italy and Germany, if you can find, they carved out their own constitution as far as their defeat in the Second World War. And you find that they wanted a regime which recognized the democratic rights of individuals, and that resulted in the, you find that the basic law of the Germans and the Italian constitution coming in 1948. Now if you look into the United States, that is America, you find that American constitution, as most of you might be aware of, it is the oldest constitution in the world, and it was started out in 1787, and you find that it is the smallest constitution in the world, and it is the shortest constitution in the world in the sense that it is subject to the minimal constitutional amendments since its inception in 1787. So, unlike the Indian Constitution, where you find that a lot of amendments are taking place, American Constitution, the amendments are very much limited. Any of you can say that how many amendments have hitherto been taken as far as American Constitution is concerned?
27.
Yes. So you find that it's not 27, I believe 24. 24. So the first 10 amendments is being called as Bill of Rights. Okay. So you find that India drafted her constitution after independence, just like your American counterpart drafted the constitution. Since America was also part of was a British colony, she happened to draft the constitution soon after her independence from the British colonial power in 1787. And you find that the American constitution followed by that the modern, after the UN Charter coming into existence after the Second World War, India attaining her freedom from the British colonization, and India adopted her constitution in 1950. So that's how it is being. You can see that the fragments of the discussions which were being held by crafting the UDHR, Universal Declaration of Human Rights, had resulted in the incorporation of the Part 3 and Part 4. Because you find that Part 3 is concerned with, is related to fundamental rights. In Part 4, yes, directive principles of state policy. Now, directive principles of state policy, you find that it is associated with your socio-economic rights, which means that when UDHR was being crafted, a lot of discussions were taking place. It said that not only the civil and the political rights of individuals should be protected, but also the socio-economic rights. And that is how you find that the policies of the government should be it should be crafted in such a way so that the socio-economic rights of the citizens are being taken into consideration. So you find that this is how your Part 3 and Part 4 was being incorporated into your constitution. So you find that the external influences were plenty while the Indian constitution was being crafted. Now I will just make a quick glimpse of, give you certain insights as to the basic fundamentals regarding the Indian Constitution. Fine. As all of you know, it is the fundamental law of the land. But before that, the fundamental characteristics of a constitution, it may be a written or an unwritten constitution. In the sense that Indian Constitution, American Constitution, all being written, you have unwritten constitution just as that of the British Constitution. British Constitution is governed by the conventions and customary practices which are being prevailing hitherto. It is an unwritten constitution, and you find that all the laws which are being made by the British Parliament can be scrutinized by the courts. So you find that the decisions rendered by the common law courts also constitutes the foundation of the British Constitution, which is an unwritten constitution. So, under the constitutional scheme, a constitution need not necessarily be written, but it also can be unwritten. Then you find that, as I have already pointed out, constitution deals with the structure and power of the government. It deals with the rights of the citizens. It deals with the relationship between government and the people, and it is supreme law of the land which must be followed. Basically, because it is deemed to be the ground norm. It is the fundamental law upon which all your administrative actions, all your legislative actions are being tested upon. Understood? Now types of the constitution, like that is written or unwritten. Written constitution, of course, it's a single document. The example is American Constitution. Unwritten constitution or uncodified constitution are spread across multiple documents such as historical precedents, legal conventions, judicial decisions, etc. And in Britain, the constitution remains uncodified. The reasons for being that both historical and conceptual. British history has remained continuous since the British Bill of Rights of 1689. You find that, and there has not been an obvious break which would have called for drafting a codified constitution. Now you find that in 2002, when the Britishers wanted a written constitution. They said that they wanted a written constitution as that of their counterpart in US in another modern constitution. We wanted based on you find that the international human rights framework which came in, and they said that just as ECHR, we want something written down so that our fundamental rights are being protected. So you find that in 1998, the Human Rights Act coming into existence, and in 2002 you find that the Constitution Act coming into existence. So they wanted something as that of a written document, since they said that all these unwritten conventions, practices, etc., were being scattered. You know, a lot of legislations, customary practices being scattered, and decisions being scattered. Therefore, we can say that we have got a constitution. You can't identify it. So we want something which is written down. So you find that the British legal system is moving towards having a written constitution. But a classic example of an unwritten constitution throughout the world is the British Constitution as such. Because Britain is being considered as a mother of parliament. The birth of parliamentary democracy world over occurred in Britain. Okay. Rigid and flexible constitutions. Constitutions which can be easily amended are called as flexible or simple constitution. Example, Canadian Constitution. On the other hand, constitutions that have a special procedure for its amendment is called as rigid constitution, which is US Constitution. Again, federal and unitary constitutions. You find that a federal constitution refers to one in which government powers that exist in the country are shared between the union government and the state, component states. Example, the American Constitution, and the unitary constitution refers to the concentration of power at the center or the central government. Britain, Italy, France, Belgium, etc. have a unitary system. Now we are coming to the main discussion of what is constitutionalism. Friends, we don't find a clear-cut definition to the terminology constitutionalism. However, it is understood that constitutionalism is the fundamental or the underlying values, principles, theories, and philosophies which limit the power of the government by law. So, as such, you find that constitution is a document which lays down the structure, character, or the nature of functions between the different organs of the government and the limitation of the government. And constitutionalism means the values, principles, philosophies which are underlying the different provisions of the constitution. Now let's look at the differences between constitution and constitutionalism. A constitution is a formal document that underlines the fundamental principles and structures of the government as well as defines the rights of its citizens. On the other hand, constitutionalism is the ideology and practice of limiting the governmental power through a constitution. So you should have a constitution where you are putting a limitation on or the state power. Okay? And it emphasizes adherence to certain constitutional principles. When a constitution provides a legal framework, constitutionalism ensures that this framework is respected and upheld in practice. You may have known about the principles like separation of powers, constitutional morality, etc. coming in right now. But you find that even rule of law concept. Can you just pinpoint and say that which is a particular provision which incorporates or which says that rule of law? Anybody in this group? Constitutional morality. So, what does all these principles mean? They can be grouped or they can be brought in under the title of constitutionalism. Got it? So, every constitution is being molded by the society in which it operates. Is it not? So, the values that particular society, the community which would adhere to this particular constitution, that is being meant as constitutionalism. Understood? Now some interesting questions for you to ponder on. The question always arises whether these rights and liberties are frozen at a time when the constitution was framed and enforced, or are they dynamic and evolved with the changing times. As I said, you find that Constitution embodies a set of rights of its citizens against the government. So the question is, you have fundamental rights under Part 3 of the Constitution. You have been guaranteed with right to equality, right to life, etc. Now, would you want the courts to give the meaning to the term right to life, which was being cast upon by the constitution makers at the time of framing the constitution, or do you want the concept of the right to life, which is today being said to be including not only right to shelter or right to clean drinking water, but also right against climate change? Do you want the courts to be dynamic in their interpretation, or do you want it to be as that of which is being contemplated by the constitution makers? You want it to be dynamic. And that is the struggle between originalism and living constitutionalism. Okay? So, the answer to this question mainly depends on the way in which the constitution is interpreted. So, the final, the person, the people who are going to say that this is what the constitution makers meant is ultimately the court. So, the court's way of interpreting the different provisions in the constitution has led to this birth of these terminologies, or a group of arguments for and against the dynamic interpretation with regard to the different terminologies which you find under the constitution. Okay. The courts interpret the constitutional provisions, of course, you would agree. Every law made by the parliament or the state legislature and every administrative act taken should be in accordance with the constitution. So, this particular way in which the court interprets the challenge which is being made against administrative action or the legislative action, the way of interpretation applied by the court has led to the birth of this particular schools of thought called as originalism and living constitutionalism. Now, originalism, that is to interpret and enforce the constitution as it was understood at the time it was originally written. The two crucial components of originalism are the claims that constitutional meaning was fixed at the time of the textual adoption, and that the discoverable historical meaning of the constitutional text has legal significance and is authoritative in most circumstances. Now, you find that while placing certain terminologies under certain provisions of the constitution, the intent of the constitution makers at that time was being discussed. And where do you find it? Yes, Constituent Assembly debates. Now, there the discourses were being held as to each and every word which was being incorporated in that particular provision. So the question is, can the courts sit in judgment over that? Because at the time of adopting those particular words, the intent of the constitution makers might have been different, and they might have had a different intent. Now, you are replacing that with the court's wisdom. Is it proper? So that is a question which needs to be addressed, and it has often been questioned world over in most of the jurisdictions, especially the American Constitution as well as the Indian Constitution. Now, for an originalist, the intent and the idea of the makers is of paramount importance. Living constitutionalism, on the other hand, is commonly associated with more modern jurisprudence. The proponent of this theory believes that the legal content of a constitutional doctrine does and should change in response to changing circumstances and values. The Constitution cannot be static for all the times to come. It has to match the needs and beliefs of the future generation. A living constitution is the one that evolves, changes over time, and adapts to new circumstances without being formally amended. So, you find that if a creative interpretation is being given by the court, at the end of it, a legislative process can be important. Is it not? You are settling the issue then and then, and it becomes a law of the land. Is it not? Why is it so? Why do you say, at least in the Indian context, why do we say that once it is being interpreted, it is a final law of the land? any provision in the Constitution says that once an interpretation is being made by the Supreme Court of India, it is deemed to be in final law of the land.
The last apex body which gives the decision of interpreted law.
No, I am talking about Supreme Court. Any decision rendered by the Supreme Court shall be treated to be the law of the land. Have you heard about this particular statement?
You said to be the court of record.
Court of record, of course, you find that it is because a contempt jurisdiction can be exercised by the Supreme Court and the High Court. I am asking about Article 141 of the Constitution, wherein it says that all decisions rendered by the Supreme Court shall be the law of the land, which means that it is as that of a legislation which is being passed by the completed legislature. Understood? So you find that you need not go into the elaborate legislative procedure once an interpretation is being undertaken. Now let's see the American experience. Friends, this World versus Connecticut, which is a 1965 decision, wherein wherein this American Supreme Court held that the right to purchase and use contraceptives was being recognized, and thus it solidified the right to privacy, which is not expressly stated under the American Constitution. Now, Indian Constitution also similar context is common. Your Kutuswami's judgment, where you find that right to privacy was being recognized as a part of Article 21 of the Constitution. Okay. In Obergefell versus Hodge, 2015, Anthony Kennedy, Justice, while upholding the same-sex marriage, went to the extent that changed understandings of marriage and characteristics of a nation when new dimensions of freedom become more apparent to new generations. The court held that Constitution does not freeze for all the time the original view of what those rights guarantee or how they apply. So the living constitutionalism was being recognized as a principle. This particular case can be related to another case under the Indian context. Anybody?
Supriya. Navjot.
Yes.
Navjot.
Okay. We'll have a discussion of it later on. But then, in the National Labour Relations Board versus Noel Canning, it's a 2014 decision wherein the court, American court, remarked that the founders knew they were writing a document designed to apply to ever-changing circumstances over centuries. So judges can give content and color to different wordings in the provisions in the Constitution with the changing circumstances. Now, you will be shocked to know that the recent trend in US is towards again sticking back to originalism. If you look into the decision of the 2022 decision of the US Supreme Court in Dobbs versus Jackson, Women Health Organization, the court showed a strong tilt towards originalism. The court overruled two of its earlier decisions, famously known as Roe versus Wade and Planned Parenthood of Southeastern Pennsylvania versus Cassie, holding that US Constitution does not confer any right to abortion. So the tri-semester rule, which was being pronounced in the Roe versus Wade case, was being taken away, and you find that right to abortion was not being held to be a part of the constitutionally conferred right under the American Constitution. The court, speaking through the majority, remarked that the Constitution makes no reference to abortion, and no such right is implicitly protected under any provisions of the Constitution. So you find that it is going back to originalism. So this is where the relevance of the discussion comes in. Let's have a look at the Indian context. Before that, we need to have a basic understanding as to how the Indian Constitution operates and what are the fundamental aspects with regard to it. I've just said that it's just a day after celebrating our Republic Day. So as all of you know, it's on November 26, 1949 that our Constitution was being adopted, and the Constitution came into effect in January 26, 1950. Of course, our constitution is the largest and the longest in the world, and it is operating in the largest democracy in the world. And it comprises of 1,46,385 words. It has 444 articles, segmented into 22 parts and 12 schedules with 118 amendments to date. Some interesting facts about our constitution. Both the Hindi and English version of the constitution, the original text was handwritten by Pray Bihari Narayan Krista. A total of 3 reading sessions were held to discuss the draft constitution before it was finally passed on November 26, 1949. To be precise, it took 2 years, 11 months and 18 days to complete the final draft of the Indian constitution. Now let's look into the Indian constitution and its journey towards living constitutionalism. The Constitution of India, as it is now understood and interpreted, is a living constitution. However, it has not been the case always. If you look into the cases decided immediately after the constitution was enforced, it gives us an idea that we follow the originalist pattern. So, initially our courts approached the interpretation of the various provisions in the constitution in its originalist mode. The classic example of it is A.K. Gopalan versus Taylor. All of you know about that particular case, but still, here you find that the originalist philosophy was being adopted. You find that the case involved the Preventive Detention Act of 1950, which allowed the government to detain individuals without trial if they are deemed to be a threat to national security. So, A.K. Gopalan, a communist leader, challenged the constitutionality of this law. In a unanimous ruling, the Supreme Court held that the law upheld the law and ruled that the citizens could be detained even without a trial if they were considered to be a threat to national security. By depriving an individual his liberty, the state only needs to comply with the procedure as laid down in the Parent Act. Understood? So, it need not be just fair and reasonable. So, what happened was that the procedure was being contemplated under the Preventive Detention Act. That procedure has been complied with by the executive. The question as to whether it is reasonable or not need not be pondered by the executive or the judicial. So, anybody can be arrested any time by virtue of a particular procedure which is being prescribed under the law. And the particular procedure should, the courts need not look into their reasonableness or fairness as such. So, this was a position in A.K. Gopalan's case. 28 years later, the Supreme Court of India overruled the decision in A.K. Gopalan's case in Menaka Gandhi versus Union of India and accepted the argument that the expression procedure established by law means a procedure which is just, fair and reasonable. This is how the due process clause of the American Constitution is being transferred or interpreted into or read into Article 21 of the Constitution. Now, if you look at the, I'm just taking rampantly certain rights and then we need to look into how the Constitution is being interpreted. Earlier view of right to privacy, if you look into the Karak Singh's decision and M.P. Sharma's decision, if you look into we look into Karak Singh's decision, wherein the Supreme Court invalidated nightly domiciliary visits by policemen to persons classified as habitual criminals. The court observed, right to privacy is not a guaranteed right in our Constitution, and therefore the attempt to ascertain the movements of an individual, which is merely a manner in which privacy is invaded, is not an infringement of Article 21. So your Article 20 but does not couch within itself the right to privacy. That's what was being decided in Karak Singh's case. This was the similar view was also held in M.P. Sharma's case. Then came the Puttaswamy decision, which we are all aware of, where you find that both these decisions was being overruled, and you find that the originalism and the living constitutionalism argument was being, if you look into the judgment, you will understand that that was being discussed, and the courts said that it is their responsibility to give a creative look onto Article 21 while interpreting Article 21 by the privacy should essentially be ready. Understood? And that is how you find that we need to respond to the changing times. That was a observation which has been made by the majority in this particular judgment. Now, if you look into another decision, that is Supreme Court Advocates and Record versus Union of India, you find that the proposition that the provisions of the Constitution must be confined only to the interpretation which the framers, with the conditions and outlook of their time would have placed upon them, is not acceptable and is liable to be rejected for more than one reason. Some of the current issues could not have been foreseen. They could have, while sitting in Constitutional Assembly debates, they couldn't have foreseen the current situation. Probably that might be the reason. And so we should give a creative interpretation. That was the observation which was being made in this particular case by the judges. Secondly, others would not have been discussed. Yeah, the current issues could not have been either contemplated, not been discussed in the Constituent Assembly. So let's not give a originalist view. Let's give them a dynamic view so that it is the Constitution is being made. The provisions of the Constitution are being made with the current challenging situations. Thirdly, still others may be left over as controversial issues, that is termed as deferred issues with conflicting intentions. Of course, if you look into the CAD reports, you will find that certain issues when there was an argument for that was being left over. And the current questions as to whether the central government has jurisdiction over the universities as far as regulating their teaching standards or the state governments. This is an argument. And the question was that what was the discussion which was taking place in the Constituent Assembly debates? And the question was that why did the Indian Constitution framers place education in the concurrent list? If it was for the Union list to make it absolutely under the Union control, why was it placed in the Union list? Instead, it has been placed in the concurrent list, which means that states also have a decisive role with regard to determination of regulation of standards, academic standards in state universities. Understood? So currently also you find that this argument coming in. So there are a lot of speculation as to placing certain entries in certain lists of the Constitution. So there were talks about it. There was no consensus, so that was deferred. So there might be situations of that nature. In that case, the court should be given the chance to interpret it in a very fruitful manner, so that it can answer questions of time, which time has raised. So that is the reason. And that was being pointed out in this particular case. All of you are aware of Keshan the Bharati versus State of Kerala, wherein again, while articulating the basic structure doctrine, the court said that Constitution is expected to endure for a long time, therefore it must necessarily be elastic. It is not possible to place the society in a straitjacket. The society grows, its requirements change. The Constitution and the laws may have to be changed to suit those needs. No single generation can bind the course of the generation to come. The Nalsa case, you find that the Supreme Court of India recognized that transgenders as the third gender, and the judgment established that transgender people have the same fundamental rights as other citizens and are entitled to legal recognition of their gender identity. The court interpreted dignity under Article 21 to include diversity in self-expression, which follows a person to a dignified life. So your life under Article 21 and your dignity under 21 is being given such a broad interpretation to include diversity in self-expression. It noted that right to equality under Article 14 and freedom of expression under Article 19(1)(a) was framed in gender-neutral terms, which means it starts with all persons, which include not only male or female but also the binary. So that was how it was being interpreted. Consequently, the equality and freedom of expression would extend to transgender persons as well. Now, Navdeep Singh Johar versus Union of India 2018 decision, wherein you find that a dancer, Navdeep Singh Johar, who identified as a part of the LGBT community, filed a petition in the Supreme Court seeking recognition of the right to sexuality, right to sexual autonomy, and right to choice of a sexual partner as coming within the fold of right to life under Article 21. And you find that petition also argued that Section 377 IPC was violative of Article 14 of the Constitution because it was vague in terms of it did not define carnal intercourse against the order of nature. The arguments of the petitioner was that Section 377 of IPC had a chilling effect on Article 19 since it denied the right to express one's sexual identity through speech and choice of romantic sexual partner. Section 377 violated the right to privacy as it subjected LGBT people to the fear that they would be humiliated or shunned because of certain choice or manner of living. The Supreme Court held that it doesn't matter how minuscule the LGBTQ is, they too have the right to privacy, which includes sexual orientation and individual autonomy. The right of partner might be different, but that does not mean that they will be punished for it. Okay, so Section 377 does curtail the human dignity and their personal choice, therefore violating the right to privacy. You might be knowing this case also. Okay, Anuradha Basan versus Union of India, the right to internet. The decision stands as a landmark position in Indian constitutional history, wherein the Supreme Court recognized the role of cyberspace as an instrument for the exercise of free speech and a tool to conduct business. So the court ruled that Article 19(1)(a) of the Indian Constitution grants constitutional protection to the freedom of speech and expression in cyberspace. Friends, we'll be knowing about this particular decision which came in 2024 only. It's a rule that right to be protected from climate change is a part of fundamental right which is enshrined in Article 21 of the Constitution. The ruling expanded the interpretation of right to life and right to equality to improve protection from climate change. This is one of the controversial decisions which came in the month of November 2024, where we are just roped into the question of whether the court is going back to originalism or should the court go to living constitutionalism. As all of you would be aware of, this particular case deals with the constitutionality of the Maharashtra law, which gave the right to the state to take over the property of the private owner's property, and the question is whether that is being contemplated under Article 39B of the Constitution, and whether the right to property under 31C of the Constitution has been violated. Now, Article 39B of the Constitution imposes a positive obligation on the state to frame policy to ensure that the ownership and control of material resources in the community are distributed in such a manner to subserve the common good. Now, what happened was that the property of the private owners was being taken for rehabilitation by the state. So, the question is that whether the state can take the property for redistribution and rehabilitation. And since we have moved far apart from socialism and we have adopted the LPG, that is what? Globalization, privatization, globalization. Whether the interpretation which has been given by Justice Krishna Iyer way back in, two decisions, Sanjeev Pope and you find that Ranganath Reddy, I'm not getting that particular decision. Both these decisions should be overruled. And the court said that the majority held that, Justice Chandrachud was in the majority, he held that this particular stance taken by Justice Krishna Iyer was not proper. Since we have gone far ahead of socialism and it doesn't hold good today, so we need not give a creative interpretation which has been given by Justice Iyer. Now, on the contrary, you find that Justice Nagaratna saying that, of course, the interpretation given by Justice Krishna Iyer at that particular point of time holds good, and we should go by it. But the problem here is, while you take a private property, you find that in the context of globalization, you have to assimilate that particular idea as to you a rightful right, that is, they have the right to property under, which is recognized under Article 31C. On the dissent side, you find Justice Dhulia coming up and saying that no, we would like to go with, we should go with whatever articulation was being presented by Justice Krishna A. So these were the three interpretations given, but however you find that it was a 9-bench constitutional court. It said that 39B, the intent given by Krishna A should be given a backseat, and the today's changing circumstances should be taken into consideration. So friends, the question is, are we on the right track? This is a debate which continues. Let's have a debate on that. So to conclude, India is a land of pluralistic society where people with diverse culture and traditions enjoy camaraderie among themselves and coexist peacefully, and thus courts need to adopt liberal and pragmatic approach and need to give life to constitutional provisions. Constitution is a living organism. It is not that with changing times the meaning changes, but changing times illustrate and illuminate the meaning and the expressions used in the Constitution. The connotation of the expressions used takes its shape and color in evolving dynamic situations. The Constitution would become a stale and dead testament without dynamic, vibrant and pragmatic